Good afternoon and welcome to another edition of CCK Live. I'm Emma Peterson and I'm joined today by my colleagues Erin Collins and Michelle DeTore. And today we're going to be talking to you about understanding VA disability decision letters, the information you need to know and what to look for. As always, if you have any questions or comments, please leave them in the comment section and we'll do our very best to get back to you. Any further reading or information you want, we do have a couple blog posts about this information on our website at ccklaw.com, so please be sure to check that out. And with that, we'll just dive right in. As I said, we're going to be talking about decision letters, and sometimes you'll hear those called notice of action letters, a cover letter. Basically, it's the couple pages that are before your actual rating decision that you receive from VA. They have changed a little bit under the AMA, the Appeals Modernization Act, to be more transparent and clear-cut for you, the veteran. So we're going to explain why it's important to understand each section of your decision letter so you can know where your case stands, what benefits you have or are receiving, and what the next steps are, what options you have available to you. So Erin, why don't you tell us a little bit about what is included in the introduction of a VA rating decision?
Sure. So in the introduction, it includes the information such as your name, your claims file number. It also could include a brief history of your time in service to include the era in which you served. So Vietnam is an example of that, and the years that you served as well. And then it also includes a brief history of your claim. So when you sent your claim to VA, maybe when they sent you a decision.
And Michelle, what does the decision section talk about?
So this is the point where you're going to find out what VA decided. So you're going to have usually them listed out by issues, and they'll say whether it was granted, whether it was denied. You'll also see maybe two other possibilities. You'll maybe see that something was deferred, meaning that VA is not issuing a decision on it yet. And it will explain a little bit later in the decision why not, but typically it's to get additional evidence. You'll also see a new possibility with the new Appeals Modernization Act rules. So if you have an appeal that you put in the higher level review lane in AMA, you will get a decision. Sometimes it says they found a duty to assist error. That basically means that in the prior decision, VA, they believe, didn't do something they should have, maybe gotten medical records or an examination, and they're basically, we call it kicking it back, but sending it to the supplemental claim lane in order for them to do that said development and then issue a decision. So those are some other possibilities rather than the grant or denial. So if they do grant your condition, they'll tell you the effective date that they're granting it from, and they'll also give you the rating they're assigning on it. I think at this point in time, it's really good to make sure that all issues you applied for are listed on the decision. And if not, then it's time to maybe check to see what happened to it, because sometimes things do get missed. But that's typically what you'll see in the next section of the decision letter.
Also included in that section is some dependency information. Is that correct?
Yeah, so sometimes VA will include in that point whether or not they're awarding you dependence benefits, especially if it was on appeal. Usually the full version is in the notification letter that comes and accompanies the rating decision narrative, but sometimes you will also see it contained in there. And it also references back to the point that if you have dependents and you're rated at 30% or higher, you should be checking to make sure VA is compensating you for them, and be aware of the fact that you have a year from that decision to submit the proper forms to get that person added so that you get your effective date to go back to the date in the decision.
Now, Erin, what's in the evidence section of a rating decision?
So within the evidence section, this is where VA lists out everything that they considered when they were making the decision on your case. So basically, it's important to make sure that you review that list and know what VA is looking for. Something also to keep in mind is that if there's something not listed, that you can submit that within your appeal as new and relevant evidence.
After you look at the list of evidence and make sure that everything you submitted or was involved is there, VA is going to get right into the meat of the decision, right? They're going to tell you their reasons and rationale. Sometimes it's more in depth than others. Oftentimes it's a few sentences. but their rationale for the decision they made, and it's going to be broken down by issue. So they will reference the evidence, maybe not. They will give you kind of an outline and a chronology of what happened in your claim. And they may or may not reference any applicable laws and regulations they used in making the determination. So, for example, if you claim some service connection claim and it's granted, they'll tell you why. For example, a 10% rating was granted for your right elbow because there is an instance where you were injured on your right elbow in service. Service medical record, documented X date, notes right elbow injury. Your VA examiner provided an opinion that it's at least as likely as not related to that injury, and you have painful motion, therefore we're assigning you a 10% rating. They'll tell you the diagnostic code that they're using to rate that particular disability. And that's something you might want to check too, because the diagnostic codes go over the various requirements for each rating. So it's good to compare what VA has assigned you with what you've been awarded. And same thing if it's been denied. They're going to tell you why it's been denied, what evidence would be needed to grant the issue, and what's missing. And that kind of leads into the enhanced notice that you get under AMA. So Michelle, why don't you go ahead and tell us about the favorable findings they are supposed to be including in these decisions?
I love the idea of this. So in the Appeals Modernization Act, they came out with the fact that now rating decisions include favorable findings. So if one adjudicator finds that you have said diagnosis or that your stressor is conceded, that is now binding on VA, meaning that beforehand, one adjudicator could say, yeah, I think this meets the criteria. It falls under, maybe fear of hostile military activity, or yeah, I think this meets the criteria for a diagnosis of a disability. But then one adjudicator could see it differently and then basically take that away. Now these findings, once one finds that, it's binding in the fact that VA can't take it away unless they find clear and unmistakable error in the fact that that adjudicator made that favorable finding. A clear and unmistakable error is a very high burden to meet. It's very rare that somebody can find it as a clear and unmistakable error. When you think about that, that basically means that, everybody sitting in the room has to come to the same understanding when they look at something. And that's not very easy to come by. And it's not based on a difference of an opinion. So it's a very high standard. So that's a new thing that I think is very pro-veteran. I'll say that you kind of see it be done differently in each decision. As Emma was kind of saying, sometimes some decisions have a lot of information, some don't have any information. Sometimes the favorable findings will have a lot of good information, and it will really kind of help you understand what elements for service connection or the higher rating that you are meeting, as well as maybe the ones you are not meeting. So I think that this is more important so much for service connection, because it will tell you, VA has conceded that you have a diagnosed disability. Here's the diagnosis. VA has conceded that you experienced a stressful event. So, sometimes then that you've met 2 of the 3 elements for service connection, and then VA is only denying you because you haven't met the 3rd element, which is a medical nexus. So I think it's very helpful for veterans. When it's done right, it's done very well. Sometimes the favorable findings will say none, and sometimes they will say information that isn't necessarily relevant. But the idea behind it, I believe, is very pro-veteran, and I think it's very helpful in the sense that you kind of could go back and forth. It's like, now once somebody's conceded it, it's kind of set in stone for you. So I think that's a really good thing to be seeing in decisions moving forward.
Yeah, so to echo Michelle, I think that's what we've been seeing in our practice in our agency side, is that these are sort of inconsistent. They are supposed to be including favorable findings, and there may in fact be a favorable finding noted in the rationale awarding you a certain benefit. For example, it's related to service, or nexus found, or diagnosis found. If it's then not listed under favorable findings, I think that that's something that you should certainly talk to your accredited rep, your VSO, your attorney, whoever you're working with about if it's going to be an issue down the road, because they are supposed to be doing this, but it is, I'd say, more than inconsistent about whether they are or are not including favorable findings in each decision. But that pretty much is going to be the meat of what you receive from VA. So we have the cover letter kind of outlining what you've received, the actual decision itself, which tells you all the evidence they looked at, and a rationale for their decision. And then this used to be sent along to veterans, but now it's not always. It's sometimes in copies that we receive as representatives for our clients. And I think you can ask for it, but I don't think that VA is automatically sending these out. But Erin, why don't you go ahead and tell us a little bit about a rating code sheet?
So with the rating code sheet, it includes all of your conditions that are subject to compensation. So everything you're service connected for. Each condition is broken down. It includes the diagnostic code, the name of the condition, and then the effective date and the ratings. Followed by the list is then what we call combined. So that is the combination of all of your service connected conditions, your total combined rating, and the effective date for that. After the combined ratings, you will see a list of the conditions that you've previously claimed but are not subject to compensation. So it could include medical conditions that you claimed years ago, but they're just still listed on that sheet as previously claimed.
And also sometimes you'll see on the code sheet if you are receiving any special monthly compensation, that will be listed. Sometimes beneficiary information is listed there too. If you've had pension in the past, that information can be listed there. So there's a lot of really good information in the in that code sheet, and it's worth taking a look at if you can get your hands on a copy of it. So after that code sheet, if it's included, you'll get a list of appeal options that you have under the AMA. And we have a lot of information on our website. We have a lot of Facebook videos about this, your different choices. So certainly check those out if you want more information about the choices that you have to appeal a decision if you don't agree with any determination VA has made. But your three general choices are to file a supplemental claim with new and relevant evidence. You can file for higher level review by a more experienced VA employee, or you can appeal to the Board of Veterans Appeals and select one of their three dockets, their hearing docket, their direct docket, or their evidence docket. And then you have you have 1 year from the date of that decision to appeal, unless you're appealing a board decision to the Court of Appeals for Veterans Claims, and then you have 120 days to do so. So maybe just in closing, if you all could share from your experience some tips for veterans seeking benefits and looking at these decision letters.
Sure. So I guess the most important thing is if you know about a decision, that you request a full copy of it. And if it lists something like an exam within the evidence and you're not sure what that exam is, that you request a copy of it so you can see everything that VA is actually looking at when they are making a decision on your claim.
I think for me, a big thing for people to look at is just to read the whole decision, to carefully and thoroughly read it, because there are things in there they'll tell you you're entitled to, like we briefly mentioned dependency benefits. There's points and times where you need to be maybe asking for additional benefits that aren't included in your decision, but benefits you're entitled to, which then usually typically the VA decisions do let you know. So a lot of times when you get the decision, you go right to the meat of it, as we were saying, like you flip right over. We do it too. We're very curious right away. And you kind of glaze over all the other stuff they tell you in the beginning because you're so focused on what they decided. And even if it's favorable, you might not go back and read the beginning of it. But there are additional benefits, like your dependency, maybe special monthly compensation, automobile adoption, stuff like that, that you might really want to be paying attention to, that you might need to file for. So that's usually my advice, is to read it very clearly and carefully, and making sure you're checking the evidence as well, because sometimes there's evidence that you're submitting that VA didn't get. And it's also going to dictate what lane you're choosing to go into when you're appealing.
And I think that brings us to the final point, which is that if you do disagree, or there is something a little bit more complicated in your decision that you're not quite sure about, please be sure to reach out to a VSO, a Veteran Service Organization, an accredited representative, an attorney, whoever you want to work with on these claims. because as we've mentioned time and time again, the AMA is complicated, it's unknown, and we are all in the process of learning it together. So you want to be sure to reach out to someone that's got some expertise in the area to help you navigate the wider range of options and lanes and choices you need to make once you get your decision. But with that, thank you so much for joining us for this discussion on VA decision letters. Once again, I'm Emma Peterson, and I'm joined today with Erin Collins and Michelle Latore. Please be sure to leave comments, and we will get back to you just as soon as we can. Or feel free to check out our website at cck-law.com, and have a good afternoon.